As our tradition, we are going to start 10 minutes late, mostly to stop last-minute stragglers from disrupting the presentation. So everybody go and sit down. And you know my policy, if you don't sit down, I'll start naming names. That's right. And that usually works really, really well. You'd be amazed. So let's see. That's on behind me. Hi. Look, see, we waited, and still one more. So my name is David Nickel. I'm president of Solar Washington, and we have an interesting presentation tonight. It's mostly related to how HOAs, homeowners associations, handle solar. So first I'll just give you a quick update on what Solar Washington is doing, kind of what we're up to. On the 11th, I believe it is, I am going to be attending a meeting with Renewable America, and we're going to be meeting with Congressman Reichert. So apparently they had a lot of wind representation at this meeting, but they had no solar representation, so they asked us to attend. So we're going to try to use that survey data that we collected a while ago in this meeting to kind of prove the benefits of solar to the congressman for his district, to show him that he's getting jobs and economic development. And then on Saturday, we're also going to be giving a presentation to a bunch of STEM students at the Pacific Science Center. So it's part of the Pacific Science Center initiative, and I believe we're going to be able to hand out solar cells and do a big Q&A and all that stuff. So it should be a really good presentation. And these are the kind of things that we can only really do because we have support of our members and sponsors. So really, really appreciate our members and sponsors. I think there's actually a thing up here that shows all of our sponsors at some point. So I just wanted to say thank you. And also, if you're not a member or a sponsor, consider doing one or both. And we don't just want you to, give us your money. We also want you to give us your ideas for how else we can be effective and what else we can do. So if you do decide to become a member or a sponsor, please also contact us with ideas from time to time, because we love to hear that. So let's see. Tonight, we are going to be hearing from first Kathleen Kapla. She is going to be discussing Northwest Community Solar's efforts to streamline the HOA process in regards to solar. And then we're going to go and move on to Don Stimson. Don is a homeowner in an HOA, and he's going to talk to us about his experience working through that process and getting a solar installation done in an HOA. And then we're going to hear from Stuart Yarfitz. He's going to talk to us about the recent rulings by the Department of Revenue in regards to solar and HOAs. And then Dave Watterson is going to come up here and give us a perspective on installing not inside of an HOA, and kind of, I think he's going to try to tell us that it can be painless. Yeah. So that's and then Jeremy Smithson is going to give us a legislative update, and that should finish out the night. And then, of course, we're all going to go have beer and dinner afterwards. So if you have time, stick around for that. But I believe first up is Kathleen Kapla, so let's all give her a round of applause.
Hi, thanks for having me this evening. My name is Kathleen Kapla. I'm an attorney here in Seattle. I have two practices, one my own, where I represent primarily commercial scale wind and solar developers, and then I'm also of counsel with the law firm of Keys, Fox & Weedman, based in Oakland, California. Keys, Fox & Weedman represents the Interstate Renewable Energy Council, and as such, we became involved in the Northwest Solar Communities effort. Next slide, please, thanks. Northwest Solar Communities is a coalition of about 20 various jurisdictions, utilities, industry partners, and citizen groups. The goal of Northwest Solar Communities is to reduce the soft costs of going solar by standardizing and streamlining permitting and interconnection processes, creating business certainty for solar PV deployment across a broad area, and facilitating the adoption of solar financing options to make solar more affordable. And IREC, or the Interstate Renewable Energy Council, supports these efforts by lending expertise in interconnection, net metering, and permitting, all of which are central to the goals of Northwest Solar Communities. In my role working on Northwest Solar Communities, my role was to focus on HOAs. And what we found was that there were a number of homeowners who wanted to install solar on their properties, but either were outright blocked by their HOAs, their homeowners associations, or their HOAs just weren't really sure how to address solar. They didn't have the guidelines to address solar. So our project at Northwest Solar Communities was to develop some model rules for HOAs that they could take and adapt to their own situation and their own homeowners associations. So we started by looking at the statutes that govern solar installations within an HOA. Next slide, please. To date, Oregon does not have a statute that addresses HOAs and solar installations. However, there is a bill pending in legislature in Oregon right now that would bar HOAs from prohibiting solar installations on any roof within an HOA community. So that's pending right now. That's House Bill 2559 if you want to track it. In Washington, the law is RCW 64.38.055. And the first question we looked at is, what does RCW 6438.055 do? Well, it doesn't require an HOA to actually address solar. It doesn't say that HOAs have to address solar. But it does say that if you do address solar, there are certain things you can say and certain things you can't say. And it does deny HOAs the right to outright ban solar in HOA communities. However, it does allow them to impose some reasonable restrictions. So this was our starting point for looking at how we would develop some model rules. What does the law allow HOAs to do, and how can we meet as many desires of the homeowners as well as the desires of the HOAs, and come up with kind of a common resolution that people could use as a starting spot. Next slide, please. So in a nutshell, this is a paraphrase, I'm sorry, next slide. The paraphrased version of RCW 6438.055 is to start with the first provision, which says that the governing documents of an HOA may not prohibit the installation of a solar energy panel on an owner or resident's roof so long as the panel meets applicable health and safety standards and requirements set by law. Then, if it's used to heat hot water, it must be certified by the Solar Rating Certification Corporation, or if it's used to produce electricity, it must meet all applicable safety and performance standards. So what this says is that an HOA may not deny a solar installation so long as it meets A and then either B or C. Next slide, please. The hang-up usually happens in subclause 2, where it says, the governing documents may prohibit the visibility of a roof-mounted system above the roof line, and it may permit the attachment of a solar panel to the slope of a roof facing the street if the panel conforms to the slope of the roof and doesn't exceed the roof line. Then it goes on, next slide please, to allow an HOA to require certain things. Allow the HOA to require the landowner to indemnify the HOA, to include other reasonable rules in the governing documents. However, the real problem becomes in the previous provision that I discussed, RCW 6438.055 subclause 2, and it causes heartburn because, go to the next slide please, because if you read it in isolation, it suggests that an HOA could deny an installation outright, that the governing documents may permit a street-facing solar installation if it doesn't exceed the roof line. And the interpretation may be, we could allow them, but we don't have to allow them at all. And that's where we've run into some questions from homeowners about what this provision means. We believe that the statute must be read as a whole. Go to the next slide, please. First, the governing documents may not prohibit the installation of a solar panel. However, they may prohibit visibility above the roof line and permit the panel to face the street so long as it meets certain requirements, not exceeding the slope, not exceeding the roof line, may require coordinating paint and wiring, and may contain other placement and manner rules. So once we looked at the statute and saw that an HOA could not deny the placement of a solar panel on a roof, but could create some reasonable restrictions in aesthetics and slope and so forth, what we did was try to design some model resolutions that were really workable. Next slide, please. And what these are designed to do is to put HOAs in a proactive position, to give them a tool that they can implement and work with their homeowners associations to talk about what fits, what doesn't fit, based on the community, the values of the community, while not running afoul of this Washington statute. It's designed for compatibility with the Washington statute, and it's supposed to allow flexibility for individual HOAs. And the ultimate goal is part of the streamlining effort, which is to promote efficient resolution of residents' requests for installation approval. Next slide, please. If you picked up materials on your way in, among those materials was an overview of the Homeowners Associations and Solar PV summary that was written for Northwest Solar Communities. The last 5 pages in this document contain the Model HOA Resolutions that we drafted. And these were a collaborative draft. They were contributed, I wrote the primary draft. There were reviewers along the way. The Washington Department of Commerce, the Oregon Department of Energy chimed in. We had a number of different parties who've reviewed them. HOA attorneys have reviewed them. And I'm not going to read them to you, but the sum of the resolution is to create a summary of an approval process. What needs to happen? What are the general requirements? That they must meet all applicable laws. That the Architectural Review Board may have a process for reviewing those, the designs, and then there's an appeal process, a notification process, and so forth. The resolutions also contain specific provisions for building integrated systems, for example, a solar carport, a solar shade over a back patio, and then there are also descriptions of a simple, a standard roof-mounted system and also ground-mounted systems. So we tried to address all of those, and we tried to do it in a very broad way. So they're not meant to be a bathrobe or a straitjacket. Like, we're not trying to make a resolution that an HOA should just adopt blindly, and we're not trying to say that every single resolution in here or description in here is going to fit a particular situation. What they're meant to do is give them that push, that nudge to look at what solar is going to do in their communities, that their residents are anxious to install solar, and they need some parameters for how they might address it. And they're designed to grow and intended to ultimately to reduce conflict. Next slide, please. So the reason I'm here tonight, and the takeaway that I hope everyone will have from here, is that if you have clients who believe they might have a conflict with their HOA, or they have an HOA who's really looking for some draft to get started, that you would take a look at these. We're also always open to feedback and thoughts about the drafts or the draft that's been prepared so far. We're interested in reaching out to HOAs directly to talk about their feedback, their response to these model rules, and and hope to get them into a position where they're able to proactively respond to their residents and take each party's position away from an antagonistic position and put it into a collaborative position. And we can do that when the homeowners have a tool that they can hand the HOA and say, here's something that can help us get this started for the whole community. So like I said, I'm not going to read the whole resolution to you. If you have questions about it, my contact information is up there. Linda Irvine from Northwest Solar Communities is also available to answer questions and to be a resource. And I'm happy to take any of your questions that you might have right now about what we're up to. I'll listen to you.
I'm wondering, so I've done a little bit of solar installation in HOAs, and my experience is always, so my experience at that time was we had a gentleman who had a south-facing roof line that faced the water, and it would literally be impossible for it to see the south-facing roof line no matter where you were in the community. Even if you're on a boat, you'd have to be in the sky to see it. And we still had to do a very long comment period and modeling period and all this other stuff. And I'm wondering if HOAs are going to start taking the tack where they can't out and out say no, but they can put so many obstacles in place that it becomes too expensive or too difficult? Is that a concern?
That's always a concern. You know, my hope with these model resolutions is that we'll provide a simple framework. But if you have an HOA that is so antagonistic to solar, and this, you know, it's only a matter of how much time or money somebody wants to throw at the, you know, on either side. It's pretty much the same in any relationship like that. So, I mean, you can definitely foresee that happening. But, you know, one of the things that we tried to do here was give some parameters to what kind of reasonable restrictions they could place, that there can't be a decrease, you know, an excess of costs, a decrease in output, and we put some limits on that. As you know, obviously they're not prescriptive. Nobody has to adopt these, but to give them a sense of what's reasonable, right? Because that's always the question for lawyers and judges, is what's reasonable. And so, you know, we thought, look, if it delays the installation by 45 days, that's unreasonable. So that's where we capped it. Like, we looked always at where is, you know, the decrease in operational value unreasonable? Is it, you know, is it 10%, 5%? And so, you know, those are the things that we gave some thought to in drafting these. But again, an HOA doesn't have to take them, and they could make it, oh, we could delay your solar project by a year. And it's just a question of how much people want to fight it.
Do you have any HOAs or representatives from HOAs in this process?
I did have one HOA attorney review the draft, and he thought it was fair and reasonable, and that was his comment. We sent it to 4 HOA attorneys who never responded, even after multiple requests for feedback, because we're really looking for some inside comments, which is why we sent, you know, I did get comments from one HOA attorney, and his comments were positive and had no recommended changes. So we thought we'd broaden the circle and see who else might have something to say about it, and we didn't get any bites. I thought that somebody would be really excited to chime in, but we didn't get any. That's why we're looking for it now.
Yeah. Have you looked?
Not as part of this effort, no. I don't know if that's been discussed. You know, I don't know, you know, how much the model rules are, you know, they're just a model. They're not intended to fit everybody. I think that would be a process that we haven't considered that yet. It's possible. Yes. One of the things we are looking to try to do is to get an Attorney General opinion about RCW, because it's 64, because of that confusion about subclause 2. I'll consider that my first victory if we can get the state AG to weigh in on that.
Hi. Have you had a situation where a homeowners association itself, as an association or as a subset of members of that association, have tried to or successfully been able to install solar?
Where the HOA itself has installed solar? I believe it's been done. I'm not familiar with it. Normally, and I should have caveated all of this, that this isn't intended to discuss condominiums where the roof is not owned by the underlying resident. I have heard in Oregon of common space installations, but I haven't actually participated in one.
My question is regarding HOAs who already have standards or in place, and what the adoption would look like for changing the rules in an average situation. Does that take a year or 6 months? Or?
Well, I've been a member of an HOA, but not every HOA moves, quickly or slowly. I think it somewhat depends. I mean, I have seen HOAs already have rules in place that in many ways look a lot like ours. And, certainly you could take the parts from here that are missing from a current HOA's resolutions or CC&Rs and suggest them. It kind of depends on how often the HOA meets and what it takes to change the bylaws and change the CC&Rs. I would suspect that's probably, in many cases, a 6-month process, but it probably depends on how quickly the HOA moves and how many votes it needs and so forth.
Once a solar project has been installed in a neighborhood, is it unreasonable for the HOA to change the rules after that?
I would say yes.
Okay.
Yeah, I mean, the idea is to have some uniformity and take the arbitrariness out. I mean, we've definitely heard stories about, one homeowner's panels being approved and then another homeowner's panels being rejected or held up for some reason. Maybe they're afraid, oh, well, we thought this was just a one-time thing. We didn't realize we were going to start this, broad-scale installation process. And the idea is to take it out of there. And it's good for the HOA, too, to take it out of that, we'll approve yours and not yours, because that puts all parties in somewhat of a litigious position, where the rules aren't being applied fairly across the board. And that's the thing about HOA rules, is they're intended to apply to everyone. So.
Sorry, I just thought of one, but are you talking about installing solar on the common area elements?
No, I'm talking about individual homes,
Okay.
individual residents.
Individual homes and residents on individual roofs.
Yes, and we've looked at condos as a completely side project from this discussion. We've looked at condos and what it takes. There are so many variations. There are situations where HOAs, would allow an easement over their common area for a particular condominium unit owner to install solar right above their own roof, on their own roof, but that oftentimes would involve, an easement from the HOA. The insurance on something like that can be prohibitive for the unit owner because they have to insure not just their inside of their unit, but the whole, the HOA's roof. And if there's any sort of hot water involved in that and the risks of damage to other units, that can be problematic. So we've kind of tiptoed into condos, but we found this was kind of the most discrete area that we could tackle at a single effort. So we really welcome you sharing this with your clients, with HOAs that your clients work with. It's not meant to be prescriptive or to that they have to adopt everything. It just gives them kind of something to work with, what it would look like for them. And as long as it complies with the state statute, they're pretty much write it the way they want.
Can you comment on why HOAs seem to be having such a hard time getting comfortable with solar or kind of getting a handle on this? It almost seems like they're either trying to ignore it and hoping it'll go away, or burying their head in the sand because it's a little too overwhelming. I'm not sure if either one of those are true, but I'm wondering what your thoughts are.
I'm afraid probably the members here could probably answer that better than I could. I suspect that there's a question. I don't live in a community that's governed by an HOA, but I believe that there's a certain aesthetic that they think they can maintain by dictating paint, trim, roof textures, and that they might lose a handle on that with solar. I mean, as I drive down my neighborhood in Northeast Seattle, I see a lot of panels and they look different. You know, some of them look a certain way and some of them look a different way. And maybe it's just that fear of losing control over the uniformity of and I also suspect there may be some concerns about opening the door to something that we included in the last page of these guidelines, which is shading. You know, some communities, I can imagine, you know, up on the ridge or something where there are a lot of trees and vegetation, that they're afraid they're going to open themselves up to, you know, well, I need you to chop down that tree to free up solar from, you know, and you can't plant that tree because it's going to grow and then it's going to shade my solar. And so I think there is a bit of like, if we just don't touch it, then we don't have to touch it, you know, that it's a tar baby. And once they've got their fist in, then they're going to have their foot in too. Yes.
Can these be easily adapted to PUD?
I don't see why not.
Thank you very much.
Thank you.
I have to admit, when I saw the meeting invite and the request for homeowners to share experiences, I wasn't sure how mine would fit in, but after seeing Kathleen's presentation, I think this is going to fit in real well. My name's Don Stimson. I'm a homeowner who was very intent on installing solar, and what I'm going to give you tonight is a very short excerpt of a long ordeal I had with an HOA who was not really receptive to the idea of solar, and hope to touch on some of the points that the reasons that they were not very receptive, as well as some of the issues that we faced applying the RCW as well. Next slide. We worked with Synergy Systems, and after exploring different options and things, we came up with the project design that's shown here. The major thing here is that we have a multifaceted roof. One side is, the rear side faces kind of southwest, and the other side faces southeast. So our plan was to install panels on both sides. The rear of our house backs up to a retention pond, and there's a green belt behind that, so there's quite a distance before there's any other residences. So there's not much view of the rear roof surface, but the side roof, there's partial visibility from the street, and that was the real showstopper in this. Next slide, please. Basically, our HOA was like many that had CCNRs, but did not have CCNRs that specifically addressed it. So it was a matter of kind of adapting what was there and trying to use what was there to determine whether or not we could go ahead. Basically, any alteration we're going to make to the exterior of our house, landscaping, anything, color, whatever, you need to the Architectural Control Committee of the HOA, and there's a set form that you use and everything. And then basically the only thing that looked like it applied to this was basically an assessment of the aesthetics of the installation and whether it fit with the rest of the community. So it's, and it turned into mainly an aesthetics issue. Now, they have a clause in there that says they have 30 days to respond, and if they use up that entire 30 days, after that, it's automatically approved. So, as you can imagine, after our application went in, I was counting the days one by one because there certainly wasn't very fast movement on it. Next slide, please. Fortunately, Kathleen went through the RCW already. The pertinent sections here again are that paragraph 2 was very important. And then the next slide has the rest of that. And of course, the bottom bullet there, that they may also apply other reasonable rules, really came into play here. Next slide, just a brief overview of our interaction with the HOA. Basically, we applied for this back in April of 2012. We didn't get any feedback from the HOA. We didn't have any questions asked of us or anything. It was just they went silent for this entire period. Of course, I was checking the mail every day, and on that 30th day, I went out to the mailbox and nothing in there. So I thought, hey, they abrogated responsibility. We're approved. We're ready to go. And I proceeded to, in my garage, I have a little bicycle wind trainer set up, and I was working out in there with I usually keep the garage door open to let fresh air in there. So I was in there and then came back into the house and noticed I had a voicemail. While I was in there with the garage door open, so you could tell I was in there, they'd apparently come by and stuck a notice on my front door, and the voicemail was to inform me of that. And that was their way of denying our application. The reasons for the denial, they had a series of 7 points, most of which were pretty strange questions and reasons that indicated they simply didn't understand what solar is about, for one thing. They didn't ask, but they didn't understand. And many of the reasons for denial were actually questions. They didn't know if there might be glare from the panels. They didn't know if 27 sounded like a lot of panels. They didn't know if that was too many. But when it came down to it, they also had a different interpretation of the state law than we did. And that we'll go into a little bit later. Well, here on the next slide, some of the wording problems we had right off the bat. The first bullet, they can't prohibit the visibility of any part of a roof-mounted panel above the roof line. Well, look up roof line. Roof line is the actual top of the roof surface. Any roof-mounted panel is going to be above the roof line. That was the first thing that they used to deny us. We responded that it was obvious that the intent was that the roof ridge or roof crest line was what the intent was. But yeah, we fought that battle all down the line. And then the second bullet here, well, the HOA may permit attachment only if, and this is concerning the panel on the roof facing the street. It's a permissive. HOA may, and they can only do that if it meets those requirements. It doesn't say that they can simply say, no, we're just not going to do it. And Kathleen brought that up, and that's what they used. Basically, this doesn't say anything that we have to allow you to put anything facing the street. Next slide here. The next thing we had was the reasonable rule clause. Basically, that was seen as an open-ended clause that they could basically put anything in there that they wanted to. Who defines what's reasonable? And basically, there was an aesthetic thing with our HOA. They flat out told us in one of the sessions we had that they consider panels to be an eyesore. They don't want them to be visible. So there's no visibility from the street. And their attitude was that even on those homes, I'll tell you later, there's about 75% of our homes have the roof side that gets the sun faces some street, one way or the other. So about 75% of those homes would essentially be prohibited from installing solar. But the HOA's attitude, the board's attitude, was that that's their choice. They can put it on the rear roof. We'll let them do that. We're not prohibiting solar. It's their choice that they want to put it on the roof that we're not going to allow them to put it on. So we're not prohibiting, but effectively they are. Next slide, please. This is the real short excerpt. Basically, the HOA ignored repeated requests to meet with them and to discuss their concerns and try to address their concerns. All the interaction was through formal letters back and forth. And of course, by this time, very early on, we retain the services of a lawyer. So they ended up being lawyer to lawyer to back and forth. And each case, when we addressed the concerns and stated, you know, how we were going to address them, we talked about the glare issue and how many panels and interpretations of the state law. Each time they came back with more absurd reasons for denying the application. So we gave them repeated deadlines to resolve this, meet, or whatever, and finally we reached the end of the line and we ended up suing our HOA, which ended up not being a fun process to get through, but it was the only way we saw to get the panels installed in the end. And we were also, or I was very interested in getting an interpretation of the state law that could be used in the future. Was our interpretation the correct one, as Kathleen said, to read it as a whole and read the intent into it? Or can you pick out pieces like, I think, similar to what's going on with the Supreme Court and the ACA right now, and read perhaps wording that's not, wasn't the best at the time, and may not reflect the intent of those who wrote it exactly correctly. But if you can take those words and read them literally and take a meaning out of that, we wanted to have that interpretation made. We thought we had a pretty good case, and so we actually motioned for summary judgment where you don't have to go to full trial, where a judge can decide. We sat in a courtroom for a day with the judge, and although he berated the HOA on many, many points, for one, not having anything in their CC&Rs addressing solar, even though the RCW had been in effect for quite some time at the time of our application. He, in the end, I kind of saw this coming where he was, you know, the HOA, you didn't do this right, you're doing this wrong, you're doing that. Then he comes up with a but. I'm going to deny the summary judgment because he couldn't decide that he felt a full trial was needed to decide whether or not their rules were reasonable under the statute. Even though if you took our intent of the RCW was to require the HOAs to allow panels on roofs facing the street if they met those requirements, and that was really the crux of the issue. He felt that a full trial was needed to resolve that. In the end, he also got on both of us that we should be talking together and try to resolve this. Don't bring it back if you can avoid that. And shortly after that, we felt that, well, our summary judgment was denied. This may give more ammunition to the HOA to fight us further, but fortunately it had the opposite effect. I think they had insurance that was paying all their legal fees. They would pay it all the way through, but would not pay any settlement costs or anything if we were to win the case. So I think their lawyer from their insurance company decided that perhaps we did have a pretty strong case, because shortly after that we got word from the HOA president that they wanted to meet with us separately without any lawyers and try to come up with a settlement. They changed their tune very dramatically, and we were able to settle, though of course you never make up everything you lose in all this, but we did end up reaching a settlement without going to full trial, so there wasn't any interpretation made either way. Next slide, please. We ended up agreeing to only install the panels on a limited section of that roof. Fortunately, Synergy was able to juggle some things around and reorient things so that they moved 3 more panels to the rear roof and situated panels on the side roof, such that we ended up with the full complement of 27 panels. I wanted to see the faces on the folks of the HOA when they saw that we were actually going to be able to install 27, when they thought they were removing about 10% of those, but or more. We never got to see that. But we both got what we wanted, I guess, in the end. And then they required an additional fir tree to be planted to further block the visibility that they actually paid for. And I'll show you where that ends up being. And then there were a few other provisions that they put in there to further reduce the visual impact. One of the things that they had wanted us to do in the original settlement offer was to actually paint all of the panels the color of the roof. You can see what I was dealing with a with a proposal like that. Next slide, please. Go ahead. Yeah. So as a result, we finally got the installation in. It took us 19 months, all told, to go through this whole thing. We did have some positive changes resulting from that. The system price went down fairly significantly in that time period, and we also had an increase in the per panel power output from 240 watts to 255 watts. So we ended up with a 6.9 kilowatt system instead of a 6.5 kilowatt system. So there were some good parts to that. Here's what it looks like. This is our rear roof. This is where the what do we got? 19 or something on there on the rear roof. And the only ones who can see this really are you can go in the backyards of next door neighbors and things like that and see it, but otherwise it's not visible at all from the street or from houses behind us. The next slide shows that side roof, and it shows the limited visibility of the panels. This is in November, so you can tell in the summertime both these trees, deciduous trees, would have leaves on them. But the additional fir tree they're having us put is in between them, so that eventually it will be like this other fir tree and all year round pretty much block view of the panels. I might add that they have planted the tree, and it will probably take about 10 or 15 years before it gets to that height, but it is there. And they also didn't do a very good job locating it, so I'm not so sure it's in the right spot, but we fulfilled the settlement agreement. The other thing is that the street, as you're going up the street, it's pretty much like this. So it's not in your field of view when you're traveling up the street. You really have to crane, and you've got a couple of seconds that you're going by that you have to try to see those panels to see them. Next slide, please. Just a quick note on what we got out of last year's performance. The expected power output was about 7,000 watts, and the actual power that was produced, we had a pretty good year. The original design, when we went into it 19 months ago, was intended to offset about 57% of our annual electrical usage. The final design with the higher power panels was about 60%, and we actually offset 72% of that estimated annual electrical usage. And then one last slide, some conclusions. We actually, I corresponded quite a bit with an aide to Senator Hobbs, who sponsored the original RCW, the bill that ended up in this original RCW, to see if we had, perhaps this was going to take long enough, we could actually get the law changed while this was still in process and fix some of these loopholes, what I would call, or fix the intent anyway. We actually talked about a bill, we talked about some wording, and to my surprise, actually, the aide to Senator Hobbs basically took the state law and everything that we had an issue with, either removed it or clarified it to the extent that the HOA had very little say in whether or not you could install a solar panel. I asked him what he thought in the environment, the chances of that passing were, and he thought it was pretty good, but unfortunately, priorities on things that are before the legislature now have really usurped that. So I'm not sure if there's where that is or if there's any chance of that going forward with the current environment. Also found that lawsuits are very expensive, they're time consuming, and they're very stressful. They're not a lot of fun. But we were intent on getting our system installed. And fortunately, we had a lot of good support from Synergy throughout this. They supported us through the motions, through the ridiculous questions, through a meeting that we had with both lawyers present, and that soon degenerated into a non-helpful session. But we were very happy with the support we received. Any questions?
Did you end up doing any glare analysis, or did they drop that?
They dropped that. No, what I tried to tell them that was explain to them that for one thing, the panels are intended to absorb rather than reflect the light. The other was at the angle that they were at, and through some basically through some internet type backup, showed them that it was unlikely that the reflection would be any more than you would get from a lawn, for instance. And they were satisfied with that. But it's really funny, you know, there's all kinds of protuberances on roofs in our neighborhood. There's people have plenty of 2 or 3 skylights and things like that. And of course, you've got satellite antennas up there, and there's restrictions on what HOAs can do with that. But for some reason, you know, it's all, this composition shingle is the essence of beauty, but a solar panel is ugly. You know, so that's what we dealt with.
What do you think would have happened if you had asked for forgiveness instead of permission? If you had just gone ahead and done the install and then dealt with the HOA later?
Yeah, there were there are a couple of reasons why. We did seriously consider that. We saw what HOA was doing with people who, for instance, did paint jobs that were not approved beforehand. And we saw that, for instance, they would assess fines, and if you didn't pay the fine, and it would be at a pretty significant fine. If you didn't pay the fine, they'd actually put a lien on your house. So we didn't want to deal with that. We also, if it did go through a lawsuit, if they did sue us, or we ended up suing them or whatever, we wanted to be on the right side of things. It wouldn't look good going into the courtroom saying, well, we just ignored the HOA and put it up ourselves because we thought we could. So those were 2 of the major reasons that we went the way we did.
Don, we have a question from somebody in our audience outside of here asking roughly, where do you live?
Roughly east of the lake. Newcastle. Roughly. Yeah, Newcastle.
I thought that looked like one of those steep Newcastle roofs. This is really interesting what you bring up about Senator Hobbs. I don't know if you're aware, but there was a bill in the House to rewrite the condo law, and way down in Section 323 was the exact same language for HOAs, but it would be for condos. It was like they just took that same. Did you know about that one, Kathleen? Yeah. So it's interesting that that you had a process started with Senator Hobbs. It'd be good to follow up with that, and also to make sure that any future legislation is so informed, because there would be a repeat of the same thing about may permit and that kind of stuff. So that's very useful.
Yeah, I learned quite a bit about some of this stuff too, and when it first started, and we thought we had a completely airtight, ironclad case before we saw you could interpret those words differently. There was an issue that, yeah, the state could have a law, but if they choose not to abide by it, it's not like you can call up the Newcastle police and have them come up and arrested. You have to sue them. And any lawsuit, it's time, money, and it's not something a lot of people would do. So enforcement is an issue as well.
Did the HOA cover your expenses?
Not entirely. Settlement did not entirely.
With the complications that you had, would you do it again? Would you sue them and go through it?
You bet. I'd probably try harder not to, but in the end, if it came up with the same situation, yes.
Just out of curiosity, has anyone else in your neighborhood pursued solar since you
Good
installed?
question. Yes. A neighbor 2 houses down who actually has a much better rear roof than we do because it's a single face, they were able to fit 33 panels on it. And they submitted an application saying that they were going to meet the same restrictions that we did. And yet they got some negative feedback at first, but finally they were allowed to do it. But all of theirs were on the rear of the roof. And, you know, I had used something similar as a model, actually, that I was trying to get our HOA to adopt some rules, and had used something similar to what you had put together. And in fact, I remember the 12-inch offset from the roof as a maximum. We ended up with, I think I might have even put 10. So our HOA, the attitude was, let's grind them down a bit to something maybe they can't accept, so they have that 5. And we ended up with, we did it within the 5, even though we thought that 6 was probably the minimum we could get. But we did it with 5, and hopefully that doesn't have any issues with circulation underneath and such during the hot summer months. But we're also, our HOA recognized after the summary motion hearing that they needed to get rules put in. And they, for a couple of meetings now, they've been saying, okay, we're going to, not just for solar, but we're going to revamp our CC&Rs in several areas. And they've asked for people to serve on that. And they've asked me specifically because they thought I would have a contrary opinion. So I'm not sure how they'll turn out, but and I'm not even sure when they're going to start. You're talking about how much time it takes to get rules in place. We've been talking about this since shortly after the settlement, which was something like September of 2013, wasn't it? No, I guess, yeah, 2013. So it takes a long time for some HOAs to get going.
Okay, we probably have more questions, but it's 7 o'clock, so we're out of time. And Don, I just want to say that I really personally appreciate that you stuck with this and kind of made it happen, even though you faced a lot of adversity. So I really appreciate that. So thank you very much. But let's all give a big hand to Don. And up next is Stuart Yarfitz, and he's going to talk about recent rulings by the Department of Revenue and how they relate to solar and HOAs.
So I'm going to talk about my experience, which was very different. I live in a community which is an intentional community. It's a condominium association. The issues that we had were not internal. We're not having to do with relationship between people who wanted to install and the association as a whole. Our issues really had to do with the Department of Revenue and trying to be able to get them to see things the way that we needed to see them. Slide control, do I have it? Yeah, okay. So Puget Ridge Cohousing Association is a co-housing community. There's a link here, which you probably, I don't know if you want to follow it, see if you can go to the link. Co-housing was a concept that was developed in Denmark in the 60s and 70s. It's been adapted here in the U.S. really since the 80s. We were established in 1994. At least that's when we moved in. It was a long process to get to the point where we were able to buy the land and build. And we have a situation where we have a tremendous amount of trust within the group and a tremendous amount of cooperation within the group. So this is very different than what other folks are talking about. We have 50, 55 people, changes. We have 23 units in 11 buildings. So we've got singles and duplexes and triplexes. And we have what we call a common house, which is a community building. We have 2.5 acres. The way that the site is organized is instead of the buildings facing the street, the buildings face central courtyards. And there's no cars internally. It's great kind of space, but it presented some different issues than what was talked about with these other homeowners association, where we didn't really have to worry about the issues of facing the street, and we didn't really have to deal very much with the aesthetic issues at all. I got involved with, I guess last summer, Northwest Seed was initiating a Solarize project in southwest Seattle and surrounding areas. Got involved on the contractor selection committee, who selected Jeremy and Evan and Addison. And a number of people in our community for years have been very interested in solar. There's a very high level of consciousness around environmental issues and carbon footprint and energy efficiency, etc. And we attended a workshop. A number of us attended a workshop this summer, later in the summer, and we were assigned Artisan, as opposed to Puget Sound Solar. And we worked very closely with Evan over this time, and the time really since August is really when we started work on this, August 2014, and he worked with him on issues of what the system would look like, and the other is sort of working with Beth Mills at the Department of Revenue, who's the person who makes the rules, does the interpretations for this program. So what we needed was, in order for this to work, we needed to be able to get all the incentive money that we could. We needed, at least the group felt that we needed to have a payback period, 5 to 6 year break-even point. In order to make that happen, we really needed to be able to maximize the tax credits and the incentive payments. And I'll talk a little bit later about how we're kind of our internal structure of how we're doing that. But next. Okay, so what we wanted to do was well, Evan did an analysis, and what we found that we had 4 southern facing roofs that would give us the payback that we wanted to get. So we focused, and that one of those was a common house, and we had the buildings C, H, and J with the other 3 buildings. And so in terms of how we would apply for this, we had 2 approaches. One was, well, we could apply as the association to do it. And the other would be the group of individuals who were interested, either as investors or lenders, or because their units happen to be in those buildings, would be the entity, essentially, that would do the installation and would own it at that point. And the key issue for the Department of Revenue had to do with this unity of ownership, which was, I'm not going to go through the wording in the WAC, but for them this is really a sticking point. And I think it really ties into the whole issue of leasing, kind of keeping keeping the companies that would be doing leasing out of the market here in Washington State. So this was the issue that we really had to struggle with. So I'll go to the bottom line, and then we'll come back to how we got there. We were able to obtain a ruling that would allow us to do the installations on the buildings that we wanted to. And we needed, in order to do, we needed to do this as a group of investors and a group of investors. And the key kind of determination here that unity of ownership was determined to exist when there's partial ownership of the property and of the system. So the initial interpretation that we had gotten was that unity of ownership would only be established if it was sort of singular. I think that what they had been working with prior to this was a situation where you had a single building, a single owner, you want to do the installation. Okay? And the other piece that we were able to get, which is what we needed, is that each unit owner who participated would be able to get up to $5,000 a year for maximum incentive payment. So next, okay. So yeah. Okay, how's that? Is that better? Okay. Okay, so Evan was our initial, made the initial contact with Beth Mills at the DOR, and initially he thought it would not be a big deal, but it turned out to be a very big deal. And you know, her initial response really was looking at this as in that model as the individual homeowner model. But yeah, you could place it on the roof of your building, right? But you couldn't put a system on another building. And as far as the common house was concerned, she felt like she couldn't really rule on that casually, that we needed, you know, to do a formal request in order to do that. Let's move on. And you know, it seems that they had very limited experience dealing with condo associations for this program. And what I get from Evan is that apparently we were the first association or group of association members, condo unit owners, who were trying to do something like this as opposed to the individual owner model. And the thing that we had to really convince them of was that all the buildings, including the common house, were owned by everyone in common. So this is really the key issue. Next slide. And really what this means is that, you know, the way we're structured as a condominium, that the unit, as a unit owner, you own your unit. Essentially, you own from the walls in. The unit is in a building. You don't own the building any more than anybody else owns the building. We all own a part of all the buildings. Okay, so that was the argument that we were making on unity of ownership. And so our request, initial request, kind of said that it specified that each of the unit owners, the 23 unit owners, had a specific real property interest in all the common elements, which would include the common house. And this is defined as all the property, all the portions of the condominium that are not the unit. Essentially, everything outside the unit is owned in common, you know, by proportional shares, depending on the criteria that we've established. And an initial request, it stated that the individual owners would own it based on their percentage ownership in the association. Okay, then we made a mistake. Before we got the result from that initial request, which really just dealt with the common house, which actually, outside of most of the legal wording in that was pretty good. We did an addendum to the request to ask about these other buildings. We wanted to be able to install on these other buildings, either as a whole association or as a group who had the resources and interest to do it, even though we didn't necessarily live in those buildings. And we made a mistake. The mistake was that in the process of developing this argument that everything was owned in common, we asserted that the association was acting as a single owner, which a single owner was being was a component of what was being required in the WAC, and that the association, on behalf of the owners, would purchase and own all the systems. So that was what we had asked for in that context. And we got a ruling in December 4th. It took quite a while. It kept dragging on, 2 weeks. We eventually got a ruling, which was totally unsatisfactory from our perspective, because it had two extreme limitations. One is that it limited to, if you want to put it on the roof of the building, you had to live in that building. Okay? The unit owner actually had to live in that building. The common house, the unit owners couldn't receive incentive money, payment money for a system that was on the common house. That was a big problem. And if the association was to do it, the association could put it on the common house. The association would put it anyways, but they would treat us like a business, and the maximum that you would be able to get incentive money would be $5,000 for the whole system, right? So this was like totally not going to work for us. So we went and decided so there's a group of us. There was a sort of a core group of about 6 people who really put a lot of work into this. There was a broader group of about 10 or 12 people who would be potential investors or lenders, and I can explain that a little bit. So moving on. Well, we're running out of year. Solarize Southwest is supposed to be contracts signed and actual installation by the end of the year. Well, by the end of the year, if you wanted to get it on 2014 taxes. And we decided at that point to go ahead with the one building, Building J, which met the criteria that was defined, that the people were prepared to own the system who lived in the building. Although it still required people would lend them money in order to be able to do that. We decided to go ahead with it. They completed it. The job was completed in January, and everybody's very happy. There's a lot of interest. Maybe I should just step back a little bit, is that we had a tremendous amount of interest in the whole community in doing this. I think, so we never really had internal opposition to the concept or around the aesthetics. We had a little concern, the aesthetics. We found out at the last minute that the modules that we were using had kind of a chrome-looking edge as opposed to a black edge, and we had some people with strong, several architects in the group who had a problem with it. But we moved on. It's not really that important. So we went ahead and kind of modified, or put a second request in to try to clarify some of the things that were raised that we thought we had a chance to be able to work with. Okay, so the question really, does partial ownership, this is this whole unity of ownership, but this partial ownership, we each partially own all the property except what's inside the units. We would partially own the system. Each person who participated would partially own the system. Should those people be able to receive the incentive payments then? It's consistent with this unity of ownership concept. And if we can do that, then can each owner then receive up to $5,000 per year, each owner of the system or partial owner of the system. So that was really what our second request had to do. This time we instead of trying to figure out the law ourselves, we have a condominium, a lawyer, an attorney who works for a firm that does condominium law. We've worked with him on other issues, and we had a conference call with him, and we asked him to draft a letter, which he did, which clarified these issues for us and ultimately for the Department of Revenue. One is that the association doesn't own any property. We had asserted the first time that the association owned the building. No, the buildings are owned collectively, and all the land and buildings are owned collectively by the owners. The homeowner owns a unit, and we collectively own all the property that's not within the unit's borders. Right? So that was really clarifying that as far as condominium law is concerned, the situation. Now the second ruling was issued recently, February 10th, and it was just what we had wanted. And we're moving ahead right now to do the installation. So we can install it on any of our roofs, including the common house, regardless of whether or not the owner of the unit owner, the owner of the system lived in the building. Essentially, that was key. And the unity of ownership criteria was met by partial ownership, which was really, again, sort of how that's the kind of the logic of how that fits. And where each partial owner is entitled to $5,000 a year, up to $5,000 a year, depending on the production. Okay, so we're going ahead with the installation. Where Artisan will honor the Solarize price, which is about a 10% discount off of what the market was at the time. although probably we should try to renegotiate because the price of the modules has come down since last summer. But anyway, it's been great working with them. We're going to hopefully we have to finalize our arrangement within the group, how we're going to do this. Installation scheduled for the beginning of April. And since we can't do this as an association, we kind of set up a club. And the club would consist of people who have different roles in the project. We have some people who have money to put in, but they don't necessarily live in those buildings. We have some, but some people with money to put in have no federal tax liability. We have other people who have federal tax liability, but they don't have money to put in. We have people who live in the buildings, right? And they're the ones who have to interface with city light. So the production meters are going to, be installed on their system. So those people are all involved. So we have a memorandum of understanding that we've been working with. Next slide. That again, the fact that we have this community that has this high level of trust means that we can actually do this. I think it would be very difficult to do it in other circumstances, which is a problem with this whole ruling, is that it doesn't allow the association to act on the behalf of the members, which is what we had asked for, but that was not consistent with the unity of ownership because the association doesn't own real property. Okay, so we have a system we're going to be, maybe I shouldn't get into it very much, but basically all the credits, incentives, net metering proceeds are going to be used to pay back investors and lenders. We have these memorandum of understanding which specifies how this is going to happen. Once the system has been paid off, which should be between 5 and 6 years, ownership will revert to PRCA. We will donate the system to PRCA, which will at that point take over responsibility for maintenance, and will then receive the net metering proceeds. So what it would mean for the units that have meters, that have the production meters, that they will be buying part of their power from City Light, hopefully none, and part of their power from PRCA, right, because then that would be by whatever net metering proceeds they would be getting would then go to the community. So basically it's shared. All of the benefits would be shared throughout the community. Let's see. Next slide. Okay, some of the lessons learned. One was working with the Department of Revenue. It took a long time. At various points it was extremely frustrating and difficult. But overall, they did listen eventually, and they did eventually come up with a ruling that worked for us. And working with Beth Mills, she was really trying to help. She was really trying to make it work, but it was really trying to do this within this bureaucratic context and with this there's very little detail in terms of how the law relates to condominium associations. There's essentially two bits. One of it has to do with whether you need to have one or more meters, and it says it doesn't matter. And the other is this unity of ownership concept. And there's also a reference which doesn't make any sense to the federal, the way the federal government would look at it. So basically, the law doesn't really exist. We did have help throughout this process from our representative, Joe Fitzgibbon, who is, I think, the chair of a committee that will be dealing with the new, what the new program is going to look like, and the new incentive program, what it's going to look like. So we were in communication with his office and with Joe throughout the process. I think at certain points they at least kind of pushed in terms of timing, well, about getting the ruling out. I doubt that they actually influenced what the ruling ultimately was, but it was good to have him involved. And clearly it was helpful. If we had talked to the attorney earlier, we might have saved several months in this. If we'd gotten that letter back, in September or October, when we had actually made this request, if we had that done, if we had done that properly, we might have been able to get an efficient, go through it more efficiently. And persistence pays off. Perseverance furthers. I mean, it was a tremendous amount of work. There was, like I said, this group of us, about a half a dozen people who just stuck it out, and we just decided we were going to make this happen. If we didn't get a good ruling, we were going to appeal it, and we were just going to go as far as we could go to make it happen. So we put copies. So Patrick put copies of these two rulings up on the. Patrick?
Yeah, they're on the website.
They're on the website. Yeah. Maybe you could show people where they are.
Well, I could communicate. I tell you what, if everybody signs in, I could send you the URL, or you can just go to our website. I will have an update about all of the files that were presented tonight on the website, on our website probably tomorrow. So look at our website tomorrow. Everything should be up there. So, solarwa.org. Any questions?
Sure.
So how was the federal tax credit situation handled?
Well, the federal tax credit situation is handled by that the owners, the people who, well, the common house, it's going to be everybody who, well, a large number of people will be owners. Their names will be on the contract. Artisan will break out. There'll be a form, whatever that particular form is. Everyone gets it to submit for their taxes. For the other buildings, the people who own the meters, who own the units in those buildings, will sign the contract with Artisan. In some cases, they will be borrowing money from other people in the group. Right, so, but they would then be eligible for it. And it's also a question of how much federal tax credit people can handle. Some people, it will take at least 2 years, and maybe the third year, and the third year is this unknown year because we don't know what's going to happen after 2017. But we think we can get pretty much all of it in that way.
What is the total cost that it's costing you for this project?
I'll know better tomorrow. Around $200,000.
About $200,000.
Yeah.
What's the size of the system?
I don't know offhand. I'm not recalling how much it is offhand. Particularly, we've made a number of changes in it. Maybe about 30 kilowatts, maybe 30, 35, something like that.
Sir? Yeah. As a follow-up to Jeremy's question regarding the tax credits, were you able to arrange for people who could use the tax credits but couldn't put any money into it to receive those?
Let me think about that for a minute. Yes, in that case, but they would need to be an owner of the system. Yeah, and they could then. How would that work as far as the tax credit? I'm sorry, if they couldn't receive the tax credit, we're doing it in such a way that they would be lenders. They would lend money to somebody else who could receive the tax credit.
Thank you. Thank you.
Which again requires a high level of trust in it. But I mean, our logic in doing that was that, well, if you were going to do this as an individual, you would get the loan from a bank, right? So in this case, we set up a system. We're charging ourselves 2.5% interest, and that's included in how we look at our repayment schedule.
My question is regarding the state sales tax exemption for individual units that have meters. Are those like under 10 kW? Then
yeah, the only one that's above 10 kW is the common house. The others are all below that, so we'll have to deal with the sales tax on that.
Going once, going twice.
All right, Stu, thanks a lot. That was pretty fascinating. I've always kind of wondered how that worked. So in a slight change of program, next we're going to have Jeremy head up. And then if we have time at the end, we're going to have Dave give his presentation on his easy installation and make all the homeowners in HOAs jealous.
Good evening. Is this on? I'll make sure people hear. Well, we're halfway through the legislative session, and so I'm going to give you an update of where we're at. It's gotten a little bit narrower in scope, but maybe not. Who knows? Next slide. But there were a bunch of energy bills. The coal plant retirement bailout, that one's caused a lot of controversy among our utility friends. The usual bills trying to get nuclear power to be part of I-937 and all these crazy nuclear bills. Bills to promote electric vehicles, extending the sales tax waiver, creating more incentives for charging infrastructure, the usual slew of anti-I-937 bills. There's a bill that would convert or create the possibility of converting the entire ferry system to natural gas. Interesting idea, actually. PODs, the one bill would allow them to sell biogas under certain circumstances. Combined heat and power for public buildings, cap and trade, which is the governor's bill. So a lot of energy bills. Unfortunately for us, we've been working with the utilities, and they kind of got distracted by some of these because they were squaring off against each other. But we have made some progress, I hope. Next slide. So these are the solar bills, and I'll just go through them quickly here. But we have the top two bills were introduced by Representative Jeff Morris, who's the chair of the Energy Committee in the House. And the next one, House Bill 1927, was introduced by Representative Jake Fye, who sits on that committee as well. House Bill 2045 is, I'll explain. It's another bill from Representative Morris. Then there was Senate Bill 5892, and the sponsor for that was Senator Doug Erickson, who's chair of the Energy Committee in the Senate. I'll explain that bill in a minute. Then we had a couple of interesting ones. There was a solar shade control bill that went nowhere, but it basically was the a takeoff on the California Solar Shade Control Act, which was passed in 1978. And it pretty much said the same thing, that once you put up a working solar system, then your neighbor cannot then grow a tree or a shrub or something in front of it. So I was really happy to see that one show up. I haven't had a chance to talk to the sponsor and find out, where that came from, or because it didn't go anywhere, unfortunately. And then Senate bill, I misspoke earlier. It was a Senate bill for the condo law. Senate Bill 5263, actually sponsored by my Senator Jamie Peterson, but Senator Hobbs was on that committee as well. He was one of the co-sponsors, so I thought it was interesting that it had that same language in it that's existing now for homeowner associations, but it would be for condominiums. So obviously, it would have to be written a little differently. So where are we? Well, the first two cutoff dates have passed. Bills have a certain amount of time to get to make certain amount of progress in the legislature, and if they don't meet that deadline, then they are essentially considered dead, except there are some circumstances under which they're not dead. So the first two cutoffs have passed, which is, the first one is the date by which a bill has to be read out of the committee of origin. So, for instance, if it was the Energy Committee in the House, the bill would have to be passed out of that committee. And then there's the next cutoff, which is a week later, is the date by which bills have to be voted out of the finance committees. That would be like Ways and Means in the Senate, or Finance or Appropriations in the House. And then March 11th is the last day for bills to be voted out of the House of Origin, and then they go over to the other house. Next slide. The only bill that actually has made it through that process on this list is House Bill 2045, to my knowledge, anyway. Next slide. So here's how I'm going to try to explain these bills. This looks confusing, doesn't it? It is confusing. Okay, so Representative Morris introduced House Bill 1301, I think it was 2 sessions ago, and then it survived, or was revived in the session, the previous session, and then this session it basically became House Bill 1097. So really kind of took some of that bill and turned it into a new bill for this session. Same thing with House Bill 2176. That was a bill that that Jeff Morris introduced last session, and that kind of morphed into House Bill 1096 this time around, and then later became House Bill 2045. And we're talking of just a span of a couple of weeks here. In the previous session, those two bills were combined into one bill in the Senate, and that went nowhere, but that same bill reappeared this session as Senate Bill 5892, and it's kind of what we call a placeholder bill. Senator Erickson's really not too interested in the details of that bill, but folks on his committee wanted to see that bill, and also, you know, he heard from Representative Morris that you know, he wanted to get a process going in the Senate. So that bill was introduced and actually passed out of that committee. It had a few tweaks in it that I think were put in there by the utilities, just judging by the way they look. But then that bill actually went nowhere. It went to Ways and Means after that, but Ways and Means did not do anything with it. So as far as I know, that bill, and it's the second substitute version of that bill, as far as I know, or no, I'm sorry, it's the first substitute version of that bill. As far as I know, it's dead, but I don't know if it's been given the special status that allows it to live, and I'll tell you about that in a sec. So getting back to these two bills, 1097 and 2045 have now been combined, and not actually, you can't find them on the website as a combined bill, but we're currently in like the second substitute version of that bill, kind of working behind the scenes with all the stakeholders and with Representative Morris, trying to hammer out the differences, and so that bill is actually still alive because it's been designated necessary to implement the budget, because it does have a cost to the state, and it's going to be a piece of that budget. Bills can be designated as necessary to implement the budget, and that allows them to, it's like a get-out-of-jail-free card. They can skip past all of the cutoff dates. Not to be forgotten is House Bill 1927. This is the result of a long process started back in June, right after Governor Inslee's Executive Order 14-04, in which he fingered Washington State University and said, you guys assemble a group of stakeholders, including utilities, the UTC, installers, manufacturers, and take a look at our solar incentives and come up with a, you know, an extension or a replacement of that program. So that's the governor's executive order. And he picked, because he works for WSU, Representative Jake Five of Tacoma, he gave him that task. So Representative Five was actually very organized about it, brought in Northwest Seed to help out, or well, he hired James Valdez from Northwest Seed to help put this whole process together. We had a lot of meetings in the fall, And it was a very useful process, but his bill went absolutely nowhere. It was read into committee, and then did not get a hearing. And I won't go into why that is, but suffice it to say there was a little friction there between Representative Fye and Representative Morris. However, you'll notice I have an arrow kind of pointing from that bill to these other bills. This bill, 1927, is actually heavily influenced now what is becoming House Bill 2045. So a lot of the elements that were in that bill that Jake Fye put together have kind of worked their way into Representative Morris' bill. And I think that, this is a result of some pressure somewhere from the Speaker, from the caucus, from the governor. Somebody is really wanting to see this, something happen. And we've also, from the other co-sponsors of the bill, like Representative Norma Smith, she wants to really see the solar program extended. So there's a lot of work going on still. I mean, there was a meeting today at noon I couldn't get to, and to discuss some of the details that the utilities are trying to work out on this bill. What is this bill? What are those bills? House Bill 1301 and 1097 concern the incentive program. House Bill 2176 and 1096 concerns net metering. As it is now, if you go to the legislature website, leg.wa.gov, and look up 2045, you'll find just the net metering portion of it. But it's actually going to be a combined bill with these two things in it. And that was really something that was asked for by the utilities. We wanted to kind of keep those separate. Like, yeah, let's get our solar program here together, and if you guys want to figure out something with net metering, fine. We'll get in there and work with you on it, but let's keep them separate. Well, they wanted the whole thing together, so this was a utility ask, and it's still a work in progress. But let me give you some idea of where it's at now. Next slide. It creates a 10-year rolling term for every participant in the incentive program. So no matter when you sign up and put up your project, you get 10 years of incentives. Those incentive rates will step down over time. So every year the incentive rate gets a little bit less for the next group of participants. If you signed up in year one, you're going to get that rate for 10 years. Then the next group that signs up in year two gets another rate for 10 years, so forth. It's really only two rates now. We had 4 or 5 different rates in Representative Fye's bill, but Jeff Morris has shaved that down to 2 rates, residential and commercial. And then third-party companies can participate in that and get that incentive. But there is a kind of what we call regulation light that they would be subjected to by the UTC. There would be an increased funding limit. That's as of this afternoon. We'll see what happens. Meanwhile, on the net metering side of it, still have net metering up to 0.5% of the peak power load in 1996 for each utility. And by the way, in Seattle, that's about 9 megawatts, and our solar is up to about 8 in Seattle. So we're getting pretty close to that 0.5%. After that, utilities can stick with net metering, or they can do a distributed energy resource study to see what effect the solar penetration is having on individual circuits. This is kind of what PSE is actually doing at the Grow community over in Bainbridge. But after hearing from utilities over and over again, hey, these net meter customers are they're freeloading. They're not paying their way because they're not buying kilowatt hours, and yet they're using the grid. And it's a legitimate argument. we're exporting energy and importing it back and forth. If you just count kilowatt hours going through the meter in any direction, it's a much busier meter than a normal house. So there is a logic to that argument, but Representative Morris is a net metered customer. So he says, let's see the numbers. Let's see what effect does that have. If you're going to have to upgrade a transformer because of this or do something else, if there's voltage regulation that has to be done because there's so many inverters, let's see that. Let's see the numbers. Well, how much is it going to cost? So this is, and we're really interested. You know, we've been hearing, well, there's a negative effect, but nobody's ever had the numbers. Nobody's ever come up with, hey, you know, this is how much. This is how it affects. Because we haven't seen those numbers yet. So hopefully this sort of thing will actually cause the utilities to give us those numbers. And then beyond net metering can happen in the current version of this bill. It could be a reliability charge. It could be which would have to be uniform across all ratepayers in a class. It could be a tariff, like a value of solar, and it would have to go through a public process. So, for an investor-owned utility customer, if you're a customer of PSE, then that's the UTC, Utility and Transportation Commission. They would have a public process, and all the numbers would have to be put on the table, et cetera. With the consumer-owned utilities, it's different. So in Seattle, it's a municipal utility, so we would be arguing these things at the city council. Or if it's a PUD, then it's going to be the governing board of that PUD that's making the determination through a public process. Once that happens, and this bill's still alive, it still has to be voted out of that committee. It could happen. It's not going to happen this week because they're all voting on the floor this week. This is the midpoint of the session, and a lot of bills have to be passed out of the House of Origin. So there's a tremendous amount of floor activity this week and caucuses and so forth. So they haven't really done a hearing yet, but there might be another hearing for this bill before the 11th. Then it's going to go to the Finance Committee, where it's going to get picked apart, by Reuben Carlisle, who's going to say, well, who's going to pay for this? Hopefully, there will be Finance Committee action that will be favorable and it'll get voted out. If it passes out with a do pass recommendation, then it goes to the Rules Committee, and the caucus and the Speaker figure out, the sponsor of the bill wants to get it on the floor and makes the case for that in the Rules Committee. Then there's a floor vote, and if it passes, it gets referred to the Senate Energy Committee and goes through the whole process all over again. It sounds laborious, but sometimes we've seen it happen in the space of 2 or 3 days to go through all of those processes. So weird things happen in the legislature when bills start to get conglomerated together in packages. We don't know if this bill is going to be part of a package, but it's already got the special status of necessary to implement the budget, so we're holding out hope that we can make something happen. Next slide. Yep, that's it. So we will be trying to keep track of that and sending out updates. Solar Washington is a really good update page on the website, so if you want to see what's happening, the latest and greatest with these bills, that's the first place you want to check.
Thank you. Any questions?
Yeah.
Will your PowerPoint presentation be available on the Solar Washington website?
Yeah. They always are.
And
yeah.
what are the numbers for incentive that are currently in the bills?
The residential has a 20 cent basic rate, and then there's a 10-cent adder for made in Washington products. The commercial rate is 16 cents and ends up at, I think it has 10 cents as well, and it goes up to 26 cents for Made in Washington. That's in year one. Then it steps down, and I can't remember what the steps are. I think it's a penny the first year, and then it's kind of more than a penny the second year. But like I said, this is a work in progress. Those rates that I just quoted you are like today's rates. So, you know, we just sent comments to Representative Morris pushing for some higher rates, like because we're concerned about losing the sales tax waiver. You know, because one thing I forgot to mention, Representative Fye used the sales tax waiver, the expiration of it, the early expiration of it, as a mechanism to pay for his program, which I thought was pretty brilliant. But Representative Morris hasn't done that, so it's kind of maybe it's a card that we can play in the Finance Committee if we have to. But we're pushing for some higher rates because we could lose that and we could lose the federal tax credit. Although some people are telling me that there's going to be some kind of federal tax credit after 2016.
For the people who already have their solar installed and they're getting their incentives through June 30th of 2020, is there any verbiage in these bills that helps guarantee that they'll continue to get those payments after this new bill is passed? Or
yeah, in every one of these bills we've pushed for basically what would happen is that program still exists. It's just closed to new applicants when the new program is enacted. So you would still get your incentives through June 30th, 2020.
What about the big problem of the McClary education issue? Have they resolved that or come close to it? Because otherwise everything could be gutted before it's over.
That's still the big one, and this was why we kind of thought Representative Fye's approach was attractive, because he could take his bill into the Finance Committee and say, look, in the first 2 biennia, first 4 years, this bill actually pays its way, and therefore is not a burden on the budget part that's needed for funding education right off the bat. Later, it's going to cost, but there are always assumptions made about the state economy. We've actually got a lot more money in tax revenue than we thought we were going to have at this time last year, because the economy has recovered more than we thought it would, et cetera. So, but yeah, that's the thing that we're going to be up against if we can get this thing out of one of the energy committees. The next thing it goes to is the budget hawks.
So if we want to try to impact this discussion, should we as residents of different legislative districts in the state of Washington, should we reach out to our own individual legislators and say, go support House Bill 2045, or?
Very good question.
Or what message should we give and to whom? Or
as soon as we have a solid bill, that would be the message. But if you want to talk to your legislators now, you can just give them, basically a general message that you're in favor of incentives to increase more solar energy and more solar jobs in Washington, and that you would appreciate their vote in favor of such legislation. That's a very general message, but we are this thing is moving so fast and changing so much. It's difficult to say, go vote for this bill, and it's not even up for a vote yet. That when first we look at the committee members in the committees that it has to go through, and if one of those committee members is your legislator, then that's a perfect time to contact them. And then when it goes to the floor, then we want everybody to contact their legislators. And we'll try to craft, a message that we can post on the Solar Washington website when we get to that point. And we can also have that general message as well for people that just want to weigh in. Because the more that your elected officials hear from you about this, the more it's on their mind. And, if you send them an email, the subject line of that email, you can say pro solar or something like that. That actually gets tallied. They actually tally the opinion from the subject line. Then they go and look at what's in the body of the email. So yeah, it's always good to get in touch. But right now, it's kind of hard to specifically say go vote for this because we haven't got a this yet. Any other questions, David?
Do you see in the current writing or version of the bill, do you see any significant concerns or fatal flaws? Areas of the bill that really would be detrimental to solar in Washington?
In the current bill, I would say one of the tough parts is a difference of opinion that apparently exists about the existing net metering law. There's some utilities that think that once you get to that 0.5% threshold, you can just stop net metering. The UTC doesn't look at it that way, and I've heard opinions from other people in the legislature that no, that's not the case. But just the fact that it's been brought up as an argument kind of muddies the water. So we're a little nervous about where net metering could go if we don't have net metering after that 0.5%. I mean, personally, I would just say let's make it a 1% threshold to give us another year to hash these things out. For some reason, our utility friends are very anxious to get this done, even though there's not a lot of solar in their districts. The ones that do have a lot of solar are not that anxious to do anything, with the exception of PSE. But yeah, we've kind of seen this weird thing where the utilities that really are most interested in hammering down net metering don't really have much net metering going on. And Seattle, they're like, once we get to that 0.5%, we're just going to keep net metering. There's an interesting, weird story behind that, which maybe I'll do a presentation on how strange net metering is in this state, because my house, my effective net metering rate is 6.8 cents a kilowatt hour. That's the effective rate, because we have 2 tiers in Seattle. And when you're net metering all summer and exporting power, they pay you in the first tier. And then if you have an electrically heated home, when you go to pull those credits out, you're paying in the second tier. So you're selling low and buying high. But oddly and elegantly enough, the more I can align my loads with that production, the higher my effective net metering rate is. I'd like to do a presentation on it because it's really interesting. I don't want to give too many utilities an idea here, but if you go to Wenatchee, you're going to net meter at 2.7 cents. There's just not a lot of net metering to get worried about here, and yet it's a big subject of discussion. Okay. Any other questions?
Quick question. One of my particular interests is solar hot water, and it's somewhat of an orphan or a forgotten child when it comes to all of these issues. I don't know that solar hot water legislation and incentives would fit into this scope at all, but are there plans a couple of years down the road from now to push some legislation for some incentives for solar hot water?
I would like to see the sales tax waiver extended for solar hot water. We got that back a couple of years ago. It left us in 2009 and came back in 2012, I think, in the middle of the night on the 11th hour of the second session. It got stuffed into a bill that had a lot of tax extenders, and we got the sales tax waiver for PV extended, but also restored the one for solar hot water. And hopefully the federal tax credit will get extended for solar hot water, because as more discussion arises about the value of net metering and the value of photovoltaic output and the the production curves of PV versus, you know, the load curves of the utility. Solar hot water actually is pretty elegant in that it just reduces your load at the very time that you're going to be using it. So you don't have any net metering, anything to worry about. It's actually a better fit for utilities. So maybe there will be some promotion of it. I don't know. It's hard to say. You can make the same amount of hot water with a heat pump water heater and 3 solar panels for a lot less money and no plumbing. So, but you have to net meter. You got to net meter that. You got to export power all summer, and then take it back when we don't have much sun. Whereas, you know, solar hot water just matches, just reduces your load at the same way that conservation would.
Well, unfortunately, it's 8 o'clock, so we're all out of time. Sorry. But thanks a lot, Jeremy, for the presentation. That was great. And real quick before we adjourn, too, I just wanted to say that we've had our last 2 meetings have been with Warren, our AV volunteer, and without Warren, our AV volunteer. And with Warren, our AV volunteer is much smoother. I really appreciate it. So thank you very much, Warren. I just want to make sure you got some acknowledgement. And as usual, some of us are going to be heading up to the pub up the street after this, so feel free to join us there. And yeah, thank you very much for coming.
any